This bond hearing immediately raises red flags. We're dealing with a year-old allegation, a late signed warrant.
And prosecutors asking for extreme cash bond, all before a jury has heard a single fact.
The real question here isn't guilt. It's whether the bond decision follows the law.
Justice Biffle, also known as Justice Myrie Jewel Biffle. Counsel.
Thanks, Judge Stevenson, for the people.
Counsel.
Good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, PA 1653 on behalf of Justice Biffle.
Can you say your P number again?
81653.
Okay, thank you. Go ahead. Anything?
Thanks, Judge.
Oh, wait, hold on. Let me see. Are you waiving formal reading, or do you want to hear the charges?
No, Judge, we'll waive formal reading and stand mute.
Court will enter a not guilty plea on her behalf. Okay, go ahead. Anything else to bond from the people?
Thanks, Judge. A matter that allegedly took place about 11 months ago. Here, Judge, the defendant allegedly gets into a fight with her sister. She had just picked her up from work allegedly. They fight in the car. The defendant allegedly stops at a gas station, drops the sister off, tells the sister to get out. Sister gets out, and then allegedly, Judge, the defendant proceeds to try to run or at least hit her sister twice. Once being unsuccessful, the second time attempting again unsuccessfully. Your Honor, the defendant then, subsequent to this incident, proceeds to go to her sister's home, busts out all of the vehicle's windows of her vehicle at her house, all of the house windows, a glass table, and then she takes her sister's license plate. Now, Judge, I realize the fact this is an incident that took place in June of last year. However, the people would like to note that this defendant is currently going through an additional matter for an AWIM, as well as a domestic violence. The people, as a result of the alleged facts in this instance, as well as the fact that this defendant is also going through a different matter, highly assaultive, we would be asking for a $50,000 cash. Sure.
Your Honor.
Yes.
That was unfortunately a gross mischaracterization of what's been happening. So let me take these two in stride. First of all, Judge, as it pertains to the allegations from almost a year ago, she is charged with attempt felonious assault, which in my experience, I've been practicing for several years, is odd because most of the time they get charged with felonious assault when the charges are serious in nature. This is a 2.5-year felony that we are talking about here, and the people are requesting an insanely excessive bond on a case that happened over a year ago. Another thing that I find odd is the warrant was not signed in this case until a week and a half ago, until May of 23, despite the fact that the allegations are from June of 22. Now, if in the people's position that my client is such a threat, why would they wait a year, in fact, to charge her on this case? The file sat there for a year and they did nothing. So it completely undercuts the people's argument that she would be a dangerous or a threat to anyone in society. With regard to the new charge, Judge, first of all, this was not an AWIM. It was an assault with intent to do great bodily harm charge with a domestic violence that was dismissed today, that I represented her on, and I waived her appearance because she got picked up on the warrant for which she's currently before your honor. My plan all along, I did not know that this old charge was pending. Again, the warrant wasn't signed off until after she was arrested on the quote new charge, which was dismissed today. So all of that to say, Judge, any cash bond is clearly excessive in this case, let alone $50,000. We are asking for a personal. She is a mother. She was let go of her job as a result of this arrest. I just think the people's characterization and request is patently unreasonable and excessive, and I ask for a personal.
According to the prosecution, this case stems from a family dispute between sisters. The allegations are serious on paper: an attempted vehicular assault, property damage, and a stolen license. But what stands out is timing. The alleged incident occurred nearly a year earlier, yet the warrant wasn't signed until just weeks before this arrest. That delay significantly weakens the argument that the defendant posed an immediate danger.
Your Honor, just with all due respect, we've been on the record for 3 hours now. I did mention the fact that there was an examination. I didn't know the final results of that, because we have been here. However, with this specific charge, I don't know if counsel has talked about any mischaracterizations of what allegedly occurred. We end up having a complainant here who ended up almost getting hit allegedly by a motor vehicle twice. And we had windows in her car, in her house, a glass table, all broken as a result of what the defendant did. Now, ironically, we didn't have any arguments regarding that characterization or lack thereof.
Okay.
And
All right.
may I briefly respond?
Go ahead.
Yeah, it's not ironic, Your Honor. It's because it's one factor that this court considers is the seriousness of the offense, right? And the seriousness of the offense is not that serious. Why? Because this is a 2.5-year felony for which her guidelines would be probation. It would be excessive to keep her in custody on these allegations, which the people did not, in fact, file for almost a year. And so it's not a matter of whether or not my client is alleged, again, to have tried to hit somebody with a car, but we're looking at the nature of the offense, the charge with which she is actually charged with. And Judge, keeping her in jail pending bond, when realistically, it's probably unlikely that this case is going anywhere. We don't know her sister wants to prosecute. So I think a cash bond would be completely unreasonable, and I'm asking for a personal.
Okay. The matters that were dismissed today, was that because the complainant failed to appear?
Yes, not only did he fail to appear, but he called both me and the prosecutor on multiple occasions, indicating that he did not wish to press charges and wanted her out of custody.
Okay. All right, ma'am, these are serious allegations. Court takes them quite seriously, at least according to the investigative report. There were 2 alleged attempts to hit the complainant with a vehicle. The court does find those to be quite serious.
Defense counsel attacks the bond request head on. They argue this is a low-level felony with probation range guidelines.
Not a case that justifies pretrial detention, even more damaging to the prosecution's position.
A newer domestic violence case was dismissed the same day because the complainant refused to proceed.
That directly undercuts the narrative of ongoing violence.
You're not to have any contact with Precious McGee. No physical or verbal contact, no contact by way of text or social media, no contact with her place of employment or residence, no contact through third parties. Do you understand that, ma'am? Yes. Okay. This matter does stem back from approximately a year ago. However, the court again feels that these matters are very, very serious. Court is going to set your bond in the amount of $10,000, 10%. You have a probable cause date of June 7th, preliminary exam date of June 12th, 2023, 8:30 a.m., 36th District Court in front of Judge Giles. Counsel, is this an affordable bond for her?
No, it is not, Judge. I am appointed counsel with the Neighborhood Defender Service.
Okay, she will have a bond redetermination hearing on this Friday, June 2nd, 9:00 a.m., 36th District Court in front of Chief Judge McConaughey.
Your Honor, is there any way I can convince the court to reconsider? $1,000 for her is tantamount to a remand. I understand.
Well, that's why she will have a bond redetermination hearing in 2 days.
The judge acknowledges the age of the case, but ultimately prioritizes the investigative report, and
emphasizing the alleged attempts to strike the complainant with a vehicle while rejecting the $50,000 request.
the court still imposes a $10,000 10% bond, an amount defense counsel immediately states is unaffordable.
This is where the case pivots from legal theory to real-world consequences.
So,
And Judge, she's looking at probation on this case. So she's not going to likely do any time as a result, even if the prosecutor is successful at conviction, which again, I don't think they are. So she's effectively sitting in jail on a charge that doesn't even warrant jail time.
well, the court sees it a little bit differently. The court has to take into consideration the information in the investigator's report as well. And so for that reason, that is the bond that will be set, but there will be a bond redetermination hearing on June 2nd at 9:00 a.m.
And just so
All right.
Judge, just so I'm clear, the court is intentionally setting an unaffordable bond because of the allegations
That is
alone.
correct.
And is not
That is
taking
correct.
and is not considering
court is
any of the other bail factors.
Court is considering all the other factors. The court is
Like-
also considering the court is considering all of those factors. The court is primarily considering the fact that the court feels that she is a danger to at least this particular individual, not necessarily the public in general.
And Judge, a person that she has had no allegations of contact with in over a year.
Well, I don't know that. I have no idea. No one has even mentioned whether she's had any contact with her in over a year. This is her sister. She very well might have had contact with her. So the court is not aware of whether or not she's had contact with her or not.
This hearing exposes a core tension in the justice system, balancing alleged danger against the presumption of innocence. The defendant isn't accused of violating any conditions for over a year, yet she remains jailed due to an unaffordable bond. A bond redetermination hearing is scheduled, but until then, freedom depends not on conviction, but on cash.